Good morning, good afternoon. Thank you very much for taking the time to meet with us today. My name is Aaron Simpson, and I'm a partner on the Global Privacy and Cybersecurity team here at Hunton. I'm delighted to welcome you to today's webinar on the latest developments with respect to legal requirements in the context of dropping cookies in the UK and the EU. Managing issues related to the deployment of cookies has become a significant issue for multinationals operating in the UK and the EU, and so today's session will be particularly timely. A few housekeeping items prior to us getting started here today. First, please note that this program is a closed session and is being recorded. We will make the recording available after the program. Second, if you have any questions during the program, please use the handy Q&A feature at the bottom of your screen to submit your questions. And if time permits, we will do our very best to address those questions at the end of the program. With that behind us, it is my pleasure to introduce you to our distinguished panelists for today's session. We have Peter Brown, who is the Group Manager of Technology for the UK Information Commissioner's Office. In this capacity, Peter leads the ICO's Technology and Innovation Service, which is responsible for handling cookie issues from the policy side, as well as for the development and delivery of technical and information security expertise on behalf of the ICO. Peter has also written extensively on the cookie issues we will be discussing today. We are also fortunate to have Clémence Scottez with us today. Clémence is the head of the CNIL's Economic Sector Department. As you know, the CNIL is the Data Protection Authority in France, and the Economic Sector Department of the CNIL is responsible for issuing guidance related to the deployment of cookies. Clémence is in charge of the private sector within the Economic Sector Department and is involved in several subgroups of the European Data Protection Board, including subgroups focused on technology and social media. Last, but certainly not least, it's my pleasure to introduce my colleague, François. Claire serves as counsel in our firm's Brussels office, and she has more than a dozen years of experience addressing complex privacy, data protection, and cybersecurity issues. Claire is a leader on our global privacy team, and she brings a practical approach to her work that is rooted in deep experience and understanding of the regulatory issues, but also the business issues facing our clients. With that, I'll turn it over to Claire to get started. Thank you.
Many thanks, Aaron. So just as a quick reminder for everyone, the European cookie rules are laid down in the e-privacy directive as implemented by each country in national law. And in the UK, they have been implemented in PECA, the Privacy and Electronic Communications Regulation. In France, the cookie rules have been implemented directly in the French Data Protection Act. And as you know, these rules require operators to obtain user consent for setting non-essential cookies and similar technologies on the user device. In order to be valid, that consent must meet the GDPR threatens consent requirement as laid down in Article 4 and 7 of the GDPR. So in light of this new requirement, DPA, Data Protection Authorities, have issued new cookie guidance. The ICO has issued its new guidance in July 2019, and at the same time, the CNIL has issued new guidelines. Why the ICO guidance was, and it still is, very detailed, the CNIL guidelines at that time were not, because they were to be complemented by recommendations on how to get user consent in practice. And the CNIL has published this draft recommendation in January. The draft recommendations, so on how to get consent, were open for public consultation. Then in June, last June, France highest administrative court, the Conseil d'État, partially annulled the CNIL cookie guidelines. In fact, they annulled a provision that imposed a general and absolute ban on cookie walls or tracking walls, a practice that requires users to accept the settings of cookies before the user can access the site or the online service. So in light of this decision from the Conseil d'État, the CNIL has revised its cookie guidelines in September, has also adopted its final recommendation on how to get consent and updated its FAQ on the use of cookies. Quickly, in terms of scope, if you are based in the UK, you are subject to PECA. In France, in fact, the cookie rules may have broader scope than the French Data Protection Act. In terms of consent, as you would expect, both set of guidance is quite similar. They stress that merely continuing to browse a site or mobile app can no longer be considered to be valid consent. Instead, users have to express consent by a clear affirmative act, by clicking on a button, for instance, or on a slider, on slider. So, however, this said, the approaches of the regulators are quite different. On the one hand, the ICO has provided some example of poor practice, meaning consent mechanism you should not implement. On the other hand, the CNIL has been quite specific on how organizations should comply with the new cookie rules, and has provided example of consent mechanisms that would achieve that compliance. So, Peter and Clémence, what are your practical recommendations for companies that are based both in the UK and in France, that operate the same website, let's say national version of the same site, use the same cookie, use the same cookie consent mechanism tool across the European website? How can they ensure compliance with different national cookie guidance and approaches? Clémence, sorry.
Thank you, Claire. I think there is a lot to say on this, and I agree with you when you said that the CNIL and the ICO's approach are pretty similar, if not identical, on the key aspects of the valid consent management platform. If you see in practice, both of our authorities stress that individuals should be able to refuse as easily as to give consent, that the consent mechanism that doesn't allow a user to make a real choice is not compliant, meaning that locating the controls in a more information section is not a good approach. It's not a good approach as well to try to influence users by emphasizing the agree or allow button over the reject or refuse button. We both said as well that user consent should be given for each purpose, which implies specific information, and that's a new thing, that individuals must be informed of the identity of the controllers depositing cookies, meaning that the list containing the identity of the controllers must be made available to them at the time their consent is obtained, and must be regularly updated. And we both said that data controllers must be able to demonstrate they have obtained valid consent to their data protection authorities. So the main difference between the CNIL and the ICO approach is in the way we presented our recommendations, meaning that the CNIL, the Data Protection Act, the French Data Protection Act provides that the CNIL can adopt guidelines and recommendations, which are two different tools. The guidelines are here to clarify the rules, the general rules, and to make sure that everyone has the same set of rules applying. And the recommendations are more about concrete modalities, examples, by which professionals are recommended to obtain consent for cookies. So these two rules are complement each other, but it's a different approach than the ICO, which published FAQs and so on. But the rules are still the same, so they can have the same approach in France and in the UK. I mean the data controllers. What do you think about that, Peter? I think we share the same view.
I think that's absolutely right, Clémence. Yeah, I mean, it's maybe, as you say, it's a different in approach rather than saying anything different. It might just be we've gone about it slightly differently, again, perhaps because of those particulars within the legislation in France that you were talking about, the different tools you have. I mean, one of the things we didn't want to do was be overly prescriptive on design choices. It gets us into a position where we might end up effectively being a co-designer with if you're being very detailed about it, and obviously for accountability purposes, it's with whomever's designing, building, implementing a consent management platform. It's their responsibility to do that. So, but I do think as well. I think I'll make this point in a number of places in this webinar. I think our guidance isn't static either. We're able to update it. We have some things we might want to add to it, which are not going to change the basic position that you've just outlined, where we're similar in what we're saying, but might be providing more practical examples. But yeah, the fundamental point is we're basically saying the same thing. So as long as the mechanism complies with what we're clarifying in our respective guidance documents and recommendations materials, that's the main point to take away. As long as it does that, there are different ways you can do that, different types of mechanisms that you can do, different design choices you can make, but as long as those adhere to what we were both saying, then effectively the same thing applies in both countries.
Perfect. Thank you both. Just maybe more precisely in terms of how to request consent in practice. So as we have discussed, the ICO guidance does not recommend any specific method or technique to obtain that consent. In comparison, as you will see shortly on the screen, the CNIL recommendation provides example of cookie consent mechanism using a two-step approach, meaning cookie banners that you can see here on the screen as the first layer of information with, as you see, a personalized reject all button and accept all button. And then if the user click on the personalized button, the user is redirected to another interface that will give, in fact, where the user will have a more, can give a more granular consent. So in light of this, and as Peter, you have said, so the ICO guidance has not been updated since July 2019. How well does the ICO feel that this cookie guidance is working in practice? In particular, would these examples that we can see, would they work in the UK? And if so, would the ICO also require a reject all button if the user has the possibility to accept all types of cookies?
That's a great question, Claire, and I think it goes to what I was saying a moment ago in when we revised the guidance last year. We weren't aiming to be overly prescriptive in how we might go about saying what you should do. We were focused really on this is what you're required to do, and there might be different ways you can do it. I mean, in respect of the approach you've talked about just now and what's on the screen, that's one approach that we have in some cases advised stakeholders when they've asked us about that can be a way of achieving a compliant approach. The key being that on that top layer you're able to refuse with the same ease as you can accept. And I think certainly historically a lot of mechanisms have just had an accept and manage approach at that layer. But there are other approaches that might, for example, involve one layer. The ICO's website has got one layer at the moment, for example, and we think the way we designed that one worked for what we are currently using cookies for or wish to use cookies for, and ours is obviously very, very basic. So I think for sort of basic uses, one type of design might work. For more complicated uses, where you might need to have a second layer, or you choose to do that banner and panel style approach on different layers, this approach certainly works as well. And I think what we might look to do as we continue to look towards updating things, particularly as we're slowly emerging out of pandemic response mode, is, start including alongside the examples of, how not to do it that you talked about a moment ago, examples of what might be good ways of doing it. So, and we're trying to get that balance right between being as helpful and as practical as possible in that guidance, whilst not overstepping and sort of saying this is the way you have to do it, whilst also, trying to be practical and trying to acknowledge there are different design choices that you can make when it comes to these kind of mechanisms. So I think, from the perspective of how well we think it's working, I think, we spent quite a considerable amount of time revising the old guidance, looking at that, what worked best there, what needed to change because of whether it was the GDPR coming into effect or just the way changes to the sort of digital economy have happened since the last guidance. And I think we took a pretty measured approach to that. I think it's worked. Your audience may have their own views, I suppose, but the point being, it's always open to being updated as needed, and to acknowledge again that there are different ways you can do this, different approaches you can take, and as long as they achieve that level of compliance, then that's great. And we wouldn't be recommending one over the other. The point being that the requirements in the Privacy Directive in PECA are met, really.
Perfect. Thank you very much, Peter. As regards the user choice to accept or refuse cookies, the CNIL previously recognized the possibility for users to delay that choice and recommended inserting a cross or X button on the consent box so that you can close it. The CNIL now considers that any user silence, inaction, or action other than a clear affirmative act expressing consent must be interpreted as a refusal to have cookies set on the device. So, Peter, does the ICO have the same position? Because I know that the ICO use TV control as a cookie consent tool, and there is a save and close button, but you can also minimize the C icon. Does this mean that users refuse to have cookies? And if so, shouldn't this be made clear to users?
Well, I suppose it's not so much a refusal, more as a lack of acceptance, and there is a subtle difference between the two. The only way that the non-essential cookie gets dropped in that sort of design option is if you've taken that action to enable it. So if you press save and close, away it goes. If you navigate away it goes. Nothing happens. So I think really the position that you're talking about is kind of where we were when we revised the guidance initially last year. So the lack of action means you can't assert or infer that there has been an acceptance. And I think that was pretty clear when we were doing the guidance in the first place, and I remember that being discussed among other authorities when the ICO was still attending those same subgroups that Clémence has referred to earlier. It's important to note, like I was saying earlier, with the different options and different design choices you can make, an X button might be the way to just get rid of the mechanism without it doing anything. There are other ways to do that, and as I said, I think certainly for our own perspective, we're sort of happy with how that's going, and as long as it's sufficiently clear, and we think if you're just focusing on hours, it's presented there with it turned off, and you just save and close, which is largely what is activated. In other contexts, it might be slightly different, as long as it's clear to the user. So yeah, that's we basically, again, we have the same position is what I'm kind of saying ultimately.
Thank you. Regarding now the contents of the cookie consent mechanism, and I think we have a question, in fact, around those lines. So it's Perfect. So we all know that that web operators must seek user consent for each type, each categories of cookies. This said, organizations are often struggling in defining cookie buckets or cookie categories, and the CNIL recommendation provide example of very specific categories and also a description, template description of that for each category, such as for content customization cookies, social media sharing cookies, and even until 3 types of advertising cookies. While the ICO guidance does not define very specific cookie category in this respect. So, Clémence, will the CNIL always require this level of details in order to obtain specific consent? Couldn't, in fact, couldn't operator regroup some categories, provided that the description below that combines the categories is quite clear. So, what is the level of information and specific and also the level of detail regarding that aspect?
I think that data control have to ask themselves what is the purpose. And they have to keep in mind that the recommendation, the French recommendation, provides illustrative examples that can be changed and adapted. For example, in our recommendation, we wanted to emphasize that data controller can inform the users that they do not use cookies for profiling purpose, but only to display advertising according to the content of their website. As a matter of fact, these cookies are less intrusive than the one used for real-time bidding and profiling purposes. So it is interesting for both the editor and the data subject to communicate more specifically on this exact purpose. That was the meaning of our recommendation. If a data controller does not want to differentiate the cookies used for profiling and the cookies only used to display a contextualized advertising, it is okay with us. It can be gathered in just one purpose, which is targeted advertising. But we also stressed in our examples that the data controller should specifically communicate on the tracking techniques used to display advertising according to the exact location of the data subject. Another example. In this case, it's quite different because the purpose is not only to adapt the advertising to the online behavior of the data subject, but also to locate his or her physical position. And this is a new purpose and an intrusive one, so data control should be transparent about this. That's the main spirit of the recommendations. You can do buckets as long as this is the same purpose. If you add something else to your initial purpose, you have to inform the data subject about it.
Thank you,
Claire.
Yeah.
Can I just add something from the UK perspective on that as well? I think it's just worth noting that one of the longer sections of our guidance it doesn't describe in the term of cookie buckets as such, but we do have a sort of table around the specific types of cookies or purposes for which cookies are used, which is very similar to what you were talking about in your question about social media sharing and content customization, user preferences, and things like that. So we have got something very similar in our own, which was a bit of a change from where we were with the previous version of our guidance, where we basically didn't have anything like that at all. And that was, again, part of trying to provide a little bit more clarification and interpretation about what we think. So, and I think I'd reiterate, the sort of overall point Clémence was making, in that, this is, at the end of the day, part of a conversation between controller and data subjects, and you have to be very clear on what it is you want to do with these technologies, and particularly in certain cases where there might be potentially more intrusive types of tracking technology being used, and it can still be the case that as long as the user makes that free choice and that choice is informed, then okay. You've still got, outside of the privacy directive's requirements, you've still got all of the data protection requirements to comply with as well. So, accountability, transparency, fairness, and etc. So, just to add in from ICO's perspective, we've got something similar in our guidance too.
Perfect. Thank you. Thank you, Peter. In terms of enforcement, the CNIL has announced that it would allow for a transition period of 6 months, or until March 2021, to comply with the new cookie rules, and thus we can expect investigation after that transition period. Clémence, will this inspection target French sites operated by French-based companies?
So we have to recall that the e-privacy directive is precisely a directive, not a European regulation. So it has been implemented in different ways in member states. So the difference with the GDPR that there is no one-stop shop mechanism, no cooperation mechanism, and so on. So if we can come back to the basics and to simplify, if we come back to Article 3 of the e-privacy directive, it states that it applies to any processing in connection with the provision of electronic communication services in the European community. So as a consequence, the CNIL can hypothetically enforce the French provision regarding cookies to data controllers aiming French citizens, but who have not their main establishment in France. So we can enforce these provisions toward data controllers who are established in the US, in the UK, and so on. It depends on many things, and in general, not generally, the target of the CNIL's inspection are defined in a more global way. We take into account, in particular, the complaints we received, the size and importance of the tracking, and so on. So I won't be able at this stage to provide a clear view of the future target of the CNIL, of the inspection department, but it will be defined on the basis of the complaints we are receiving, mainly.
Thank you, Clémence. And Peter, what about the ICO? Because I know that it was a priority for cookie compliance was a priority for the ICO. Are any cookie inspection on the horizon as well?
So I think this might partly overlap with a later question on online targeting more generally, but you know, as your colleague said in the introduction, I'm in the policy side of the ICO, so we do work quite closely with our colleagues in the enforcement areas. And I think the other thing to note is, certainly from just my own personal perspective within the ICO over the last, what is it now, 7 months, 8 months, a lot of our focus has been on helping with the response to the pandemic. So that's not to say that you know, none of this sort of activity might is not going to take place. We're coming out of that sort of response period right now, and I think we operate probably very similarly in a way to Clémence was talking about. You know, we have to act in a proportionate way in any regulatory approach we undertake, targeting, you know, the sort of areas where there is greatest harm and risk of harm to individuals, and that can involve you know, receipt of complaints, like Clémence says, we will get those as well, but we can do certain things like looking at certain sectors or doing thematic reports and things like that, which might inform future regulatory activity yet to be decided. So I think it's, again, I can't specify, you know, there'll be X number of cookie investigations specifically starting in January. That's not how things operate, and you know, we have to take that sort of measured approach. So nothing's off the table, nothing's on the table.
Perfect. Thank you, Peter. Clémence, so the CNIL cookie guidelines initially made it clear that the CNIL may take corrective measures and sanctions based regarding cookies independently of the GDPR cooperation and consistency mechanism, because at the end, these rules are based on the e-privacy directive and not the GDPR. Then this statement was removed from the final guidelines, so the revised version. Does this mean what in terms of no cooperation between data protection authorities?
No, this part was deleted from the original version because it was something already stated in the law. At some point, we didn't have to replace every provisions and every statement in this recommendation, so we have chosen to delete it, but there is no intention behind this. And as you know, the privacy directive refers to the data protection regulation that defines the notion of consent, purpose, and so on. So, as a consequence, the interface between these two regulations is often discussed between European DPA to reach a common understanding. The revision of the guidelines regarding consent on May this year is a good example on this matter. And even if the e-privacy directive does not provide for a consistency mechanism in itself, the DPAs are careful to share their interpretation and discuss them within the EDPB. And we had several occasions with Peter to talk about this in specific subgroups, for example.
Thank you, Clémence. Speaking of the future, so both the ICO guidance and the CNIL FAQ on the use of cookies refer to the proposed privacy regulation, so that will replace the privacy directive, and which is intended to harmonize the cookie rules. The discussion is still ongoing within the Council of the EU. Peter, in light of Brexit, should we expect some divergence of the UK cookie rules from the privacy regulation once finalized? And if so, in what areas can we see some difference?
I expect this is probably the question that a lot of the audience are on the edge of their seat for, and I'm going to have to disappoint a lot of people in my response, and it's not because I don't want to, provide some useful input or anything like that. I mean, the only thing I can really say is we're still currently in the transition period of the withdrawal agreement. When that period ends, end of this year, the overall data protection regime we've got in the UK, including PECA and the Privacy Directive, will be the same as it is at the moment, as it was this time last year, etc. So there will be close alignment, and really any future development of the UK data protection framework is really a matter for the UK government. We regulate the law that's in place for us to regulate. So I'd sort of defer to that really more than anything else. On the the e-privacy regulation itself, yeah, we thought when we were drafting the new cookie guidance last year that it's not something you could avoid mentioning for obvious reasons. It's potentially going to be quite a significant change to the regime, even just by virtue of it being a regulation rather than a directive. But obviously, it's taken some time to get to where it's got to at the moment, and in that time we've gone into the withdrawal period, and will be that period will end at the end of this year. So we still have the current national transposition of the Privacy Directive in PECA that will still be in place as of January the 1st next year, and any potential change to that is ultimately a matter for government. I'm sorry, I can't be more helpful on that one.
No, thank you, Peter. This is very helpful. Let's maybe briefly address the cookie issue, but in the broader context of the ad tech industry, because so the CNIL cookie guidelines and recommendation were part of the CNIL online targeting plan for 2019 and 2020. Clémence, will there be another online targeting plan for the next year? And if so, what action could we expect?
I think it will be the same plan because, as you may know, the original plan has been a little undermined by the current COVID crisis. We planned initially to adopt the guidelines on April, not October, and this delay has impacted the plan, but it remains the same mainly. So our plan for this year will last next year, and we will investigate the application of the principles set out in our new guidelines 6 months after the adoption, which brings us to the end of March 2021. So yes, it's still the same plan, and there are still investigations which are going to be performed at the end of the transition period of 6 months.
Thank you, Clémence. Peter, the ICO has been investigating the AdTech real-time bidding industry and then decided to pause in investigation due to the pandemic. Has the ICO restarted its work in that respect? And if so, when could we expect the outcome of that investigation? And what action, enforcement action, is likely?
So as I touched on a couple of questions back, and as you've acknowledged, we issued a statement fairly early on during the pandemic about certain ongoing areas of work that were being paused or slowed down because of the resource demands on that response, and the work we were doing into AdTech was one of those. But I think it's important to note that pause does not mean finished, does not mean ended, does not mean never coming back to. So a number of my areas actually, not even just on issues like cookies and AdTech, were we had to sort of deprioritize for those, I think, very sensible reasons. Since then, you may have seen that generally, I think we're emerging, as I said a couple of times on this webinar, from that sort of immediate response period, and a number of areas of work have been restarted. I'm sure most of the audience will have seen the 2 significant fines we issued recently for BA and Marriott and things like that. That was work that has now been able to be completed, and we've taken certain action throughout this period in the area of things covered by the Privacy Directive, like spam texts and things like that, particularly with a COVID-19 angle to them. So I think it's important to say all of that first, which is a bit of a long introduction. And you may also have seen recently we published a report into the data broking industry in the UK, which sat alongside some enforcement activity that we'd announced against one data broker in particular. And within the back of that report, we do refer to the work in AdTech. So I think what I'm kind of saying basically is that as we essentially return to, I'm not going to say normal, it's a new normal, but as we return to this new normal and we start to unpause work that has been deprioritized for the pandemic response, I think, you will start to see some more activity along the lines of what I've just said. And I think it's also, important to note that we've kept the wider world sort of regularly updated on what we were doing in the AdTech work during 2019, from when we published our report and when we held our fact-finding forums, and when it's appropriate for us to say something else, I think you will see something. So I can't say more than that at the moment in terms of the sort of specific things you're asking about. It's a very similar position to what I said in response to your question on enforcement more generally.
Thank you, Peter. We have, in fact, a lot of questions, and also some questions on analytics cookies. One question from Prieto is whether, in fact, it's an area where the ICO and CNIL differ on analytics cookies. The Privacy Directive does not envisage whether to consent for analytics cookies, while the CNIL does, and subject to certain conditions. May the ICO reconsider its position on analytics cookies in the future? I do not fully agree with the difference in this respect, because there is indeed one exception from the CNIL, subject to conditions that has been softened a little bit, but Google Analytics, correct me, Clémence, if I'm wrong, will not benefit from that exemption. But the ICO has mentioned in its guidance that the priority will not be to look after, to look at first-party analytics cookies. So the position is not so different. Peter, do you have something to add on this? Do you see a difference?
No, I was essentially going to say very much what you just said yourself, Claire. I think in practice, to my mind, the positions between the two authorities are very similar. I think it's also worth noting that, and this is part of, one reason for there to be any privacy regulation to replace the directive is there have been different approaches taken in different member states as regards things like analytics. So certain countries did write additional exceptions into their national implementations. The UK didn't do that with the privacy directive. So again, we were looking at it very much from the point of view of, well, this is the law we've been given to regulate, and this is what it says, and that's how we interpret it. But at the same time, I think, as far back as the Article 29 cookie consent guidelines from, I think, 2012, which is actually before my time at the ICO, but I think my former manager might have been involved with that in some way. The Article 29 recognised there the utility of some of these this type of low privacy risk cookie and how that can assist organisations in what they're trying to achieve. And ultimately this has sort of found its way up to the European legislator in the initial Commission proposal for the EPR, which includes the exemption for web audience measurement. So it's not something we're unaware of and have not had sort of thoughts on when we were developing that guidance, which is why I think there's that wording you referred to about that certain types of low privacy intrusive use of cookies like the ones you described. You need to sort of factor that into where's the area of greatest harm to individuals. And if you compare it, I think Clémence made a comparison earlier on to certain types of cookies like that versus I think it was in terms of advertising. I think the comparison was made, but certain types of cookies pose a low risk to privacy and a low risk of harm than others do, and it's about targeting in a proportionate way where the areas of greatest harm occur. So as I say, I don't think we're massively different in how we view things, particularly uses of third-party analytics, for example.
Thank you.
May I add something about the French exemption?
Sure, Clémence.
It's just about audience measurement. I think we do not call audience measurement the same. We do not put under this name the same practices in general. In France, audience measurement, which is exempted, is only aimed at producing statistics, not following one individual to see exactly what he's doing on a website to improve this website. So this exemption is in practice reduced to some concrete practices, but counting people, not following them, to simplify the explanation.
Thank you. So we have also a question, and I think from an anonymous attendee, and this relates in fact to the scope of the cookie rules. So the question is the following: what is the position on global sites, for example US, and their requirement to include an EU compliant cookie consent mechanism? So would this global site have to include an EU compliant cookie mechanism? Is the expectation that an EU compliant consent mechanism is deployed where any EU visitors access a site, or is it acceptable where EU visitors are incidental to a site, so that is to say there is a local site for US users, so they don't need to access the US global site to not include an EU compliant customer mechanism. So the question is regarding the scope. I've noted with interest that the ICO cookie guidance mentioned that the PK rules do not apply to overseas so hosted website, but still, to the extent that the cookies collect personal data, the GDPR notice and consent requirement will apply. And thus, so you need to provide clear information on the cookies and obtain consent in light of the GDPR consent requirement. Peter, do you see anything else to add? Would it be okay to have the tool on a local site and so that to make a distinction between the global site and the local one?
I mean, I think most of what we got to say on that right now is, as you say, is in our specific section on overseas websites in the guidance. I think we don't have too much to add on that really at the moment. I mean, how an organisation wants to approach the topic is ultimately a matter for that organisation to take, and we're not advocating, like necessarily doing one thing or the other, or preventing access might be one way. If they want to take that decision, that's a decision for them to put in place. There might be other ways of doing it, as long as wherever those methods trigger particular compliance requirements, those compliance requirements are met. I think we wouldn't be saying much more than what we say in the rest of the guidance at the moment.
Okay. Thank you. We had also we have also some questions, a tricky question. What can business do to gain acceptance of cookies if incentivization is not allowed? So basically, if customers reject all cookies, how can digital business still exist if it doesn't know what is if the business doesn't know what the customer are doing on the site? And the new rules are quite indeed, I would say, well, there is now you need to have a clear positive act. So what if users do not express this positive act? For some business, like having advertising cookies, it's quite key. Do you see any practical recommendations? So the ICO has mentioned there is a need to have to present the cookie consent mechanism in a way that disrupt a little bit the user experience. So in order to force users to interact with the tool, any recommendation in that respect?
So is that one for me as well, Claire? I think.
Okay, Clémence, as you wish.
Go ahead, Clémence.
Okay. There are many ways to implement a consent mechanism, and we do not have a general recommendation. Sometimes it depends on the kind of relationship you are trying to build with the data subject. If you're a merchant, an online merchant, journalist or so on, it's different. Your data, your visitors are not expecting the same from you. So we are not pushing one recommendation over the other. We are not prohibiting a general communication saying we do leave. Our revenue is based on cookies, so please, can you help us to get along with this new recommendation? But you still have to be specific on the proposals and make sure that people really accept and grant, yes, a specific agreement for this kind of tracking. And if there is no consent, yes, the tracking cannot occur. That's the main point. There is no right to track people. That's the main spirit, I think, of the regulation.
Perfect. Thank you, Clémence. Maybe so we had a question also regarding your views on mechanisms that aim to standardize user disclosure and consent collection mechanism, like the EIB standards. So what are your views on these standards? Are you, do you consider them fine? Are you working on with business organization to have compliant and template and so to achieve indeed compliance? Clémence or maybe Peter, do you have any views?
Peter, if you want to go ahead.
Okay. I think the concept of a some kind of standard by which compliant practices within the realm of the Privacy Directive can be attained is it's a good concept. I mean, I refer back to previous things I've said here about being having to walk a line as a regulator between providing advice and guidance and assistance in that kind of aspect and not stepping over into co-design. I think one of the differences between the e-privacy directive and the GDPR is the latter having things in it such as mechanisms like codes of conduct, which don't specifically appear in the privacy directive as it currently stands. But that's not to stop sort of voluntary practices doing very similar things, and I think that might be a useful route forward. I can't say anything about specific implementations that are currently in the market for obvious reasons. But as a general approach, as long as they are these sort of proposals or standards or whatever they may be, achieve the outcome, that's the main thing. Making, as I say, no comment either way as to whether ones that are existing do or don't.
Perfect. Clémence, you want to add something?
Yes, thank you. At the CNIL, we are encouraging this kind of initiative because we are talking about an ecosystem which has to agree on a common approach regarding consent, because consent is not only for the editors, for the ad tech actors, for publishers, and so on. So we cannot. I totally agree with Peter. We cannot co-design the platform, but we can answer specific questions from these actors to build something that is compliant with the regulation. So we are advising, but not co-designing the platform. And we think that it's a great initiative. Any initiative involving the whole ecosystem is a great initiative to achieve compliance.
Thank you, Clémence. We had one question on cookie rules. So the question is, how do you see, do you see that the ICO and the CNIL approaches, are they different with respect to cookie rules after the Conseil d'État decision? My personal view is that they are not, because the revised guidelines say that the lawfulness of this practice has to be assessed on a case-by-case basis. And Peter, correct me if I'm wrong, but the ICO also seems to suggest that, well, it is quite unlikely to obtain valid consent, but he has also to be assessed on a case-by-case basis. So at the end, your approach seems to be quite also similar, maybe not purely identical, but similar on this point too. Do you agree?
I think that seems right to me. It was one of the aspects of the guidance revision that was, that we did spend quite a lot of time on, and I think we ended up with what I think is a nuanced but appropriate position, which is, well, as it says in the guidance itself, really, we don't necessarily use the words case-by-case basis in there, but I think that's kind of what we're saying. So, I think I'd concur with that.
Thank you, Peter. We had also one interesting question regarding websites, in fact, directed at children. Can children accept cookies for personalization? So, and how does the GDPR parental consent requirement for underage data subject, so below 16 or depending, of course, of the local, 15 in France and 13 in the UK, come into play here, if at all. So how do you combine, in fact, the GDPR parental consent requirement with the e-privacy directive requirement here when you have a website directed at children? Clémence, it's a good question.
It's a tricky question, very tricky question. We don't have the answer. We do not have the answer because it depends on the website, and I'm just sharing a personal interpretation, but basically I'm not that sure that the Article 8 of the GDPR directly apply in this case, because we're in Article 8, you're talking about the legal basis according to Article 6, which is a legal basis different from the consent provided by the e-privacy directive. But there is still the question of the validity of the consent of someone underage and the parental authorization. And I don't have the magic solution for this kind of cases. And I think website targeting children must have some thoughts about this and maybe some solutions. Just on, yeah. Sorry, Claire. Just on that point from the UK, we have a specific statutory code about age-appropriate design, which was in our Data Protection Act 2018, and we've spent the last couple of years sort of fleshing out what that code should look like and what it should say, and we released the final version of it in September this year with a 12-month implementation. It's built on the GDPR, so everything in it is drawn from what the GDPR says, but we also do have provisions in there about things like targeting, use of cookies and things like that for obvious reasons, because it's about online services. So the code's quite a lengthy document, so I'm not going to try and summarize it in 60 seconds time remaining, but I think, you know, if the audience wants to know more about online services and the processing of children's data and things like profiling, targeting, geolocation, use of cookies, go and have a read of our age-appropriate design code, because that's where we kind of encapsulate all of that.
Thank you, Peter. I know that we are running out of time, but maybe a very quick and easy question. Most websites, Clémence, offer two options on their cookie banners: accept all and manage cookies. Is this approach considered acceptable by the CNIL? I think now we can say no. If you have an accept all, you need to have a reject all button, or at least a possibility like a link where you can say continue without accepting. Is that correct?
Yes, it's totally correct. You have to they have to offer you a way to accept and refuse as easily, and the parameter and or more choices button is not sufficient.
Thank you.
All right. Well, thanks, everyone, for joining our program today. We really appreciate it. If you're interested in staying up to date on these and other important global privacy developments, please take a look at our privacy blog, which you can find at www.huntonprivacyblog.com. We provide updated content multiple times per day and have hundreds of thousands of visitors. And we also look forward to having you at future events. I hope you have a nice morning and a nice afternoon, depending on where you're located, and thanks again. Goodbye.